This is a court. When you come to court, please dress appropriately, okay? So just so you know, you're not here alone. Your lawyer is here with you on Zoom. Ma'am, you were placed on probation in this court.
Right away, the judge makes it clear this isn't about guilt or innocence anymore. It's about whether this woman can follow the rules of her probation. The stakes? Her freedom.
In 2022, we've had many, many issues. Our first motion to adjudicate was filed, it appears, in November of 23. You were placed back on probation. It looks like a new motion has been filed in February for a variety of things. A warrant had been issued, and I guess now you're here with us. I just don't know how to go forward.
That's why.
Stop. Don't need you to.
Just listen, please. Don't say
Just
anything.
understand that, now it's not time to fight the case. The only thing that we're dealing with now is the motion to revoke, the underlying issues. And what I see is that you're still testing for illegal drugs. I don't know how to go forward, but I don't want to set you up to failure, to set you up to fail as well. So what we do is we have something that's called a TRAS, where I have you evaluated by.
Notice how the judge emphasizes rehabilitation over punishment. But here's the twist: can someone really leave better than they came when they're constantly being pulled back in by a broken system? What would you do if you were in her shoes?
Clinicians to see what is the best way to go forward, because I just don't know. The last thing I want to do is just start pleading people guilty here, left and right, and just end up with, conviction after, no. So the idea is that you leave better than you came. It still hasn't happened. So we need to find out how that's going to happen. So I'd like to please set up for TRAS. Your bond is set now at $10,004. So I have to take you into custody because of the warrant. So I will try to get it done as quick as possible. We could probably have the TRAS done. Do you think maybe tomorrow?
She'll probably still be in processing tomorrow, but by the end of the week.
Okay, we'll try to have it done by the end of the week. They will give us guidance on how to move forward, because I just don't know at this point. The only thing I'm going to tell you is please be honest, because if I get it and it says that there's no issues and it's rainbows and gumdrops, and I know it's not true, and we're going to do it right over again. Okay? Okay, so she goes with you. Okay, thank you, Mr. Verney.
And Your Honor,
Yeah,
if possible, can we try to get the TRAS done by Thursday so she could be in court Friday? Because I'm out.
I will. I'm going to try. So the problem is, though, is that what takes a lot of the time, Brock, is the processing. Because we're taking her in now, it's nearly 11 o'clock. They'll probably still be processing her early into tomorrow. If she's still in processing, they can't get it done. Maybe in the afternoon, tomorrow afternoon, they can get it done. I would say probably the latest, today's what, Tuesday? Maybe the latest is Thursday to try to get it done. And then we can try to get the results by Friday.
Okay.
And that's
Put it on the
if
docket
everything
for Friday.
goes.
Few third case into years, and the judge is done playing. That bond reduction request shut down fast. This court's clearly saying enough is enough.
Yeah,
Can
hopefully.
we put it on the docket for this Friday, Your Honor? Like I said, I'm out all next week. I don't want her to.
So because she's in processing, because she'll be processing now, she will auto-populate on tomorrow's docket.
Okay.
And we can put her on for the Friday. So I
Sounds
can't
great.
really put her on for Friday yet because she'll auto-populate for tomorrow. But tomorrow, then I will put her on for Friday.
No problem. And can you consider reducing the bond somewhat, Your Honor?
No. This is our third case within the last two years. We've had multiple MAJs. I mean, she's doing what she wants to do, and that's it.
I understand, Your Honor.
Thanks, Brock.
No problem. I will see you Friday.
Okay. I'll reach
Have
out
a
to
good
you tomorrow because she'll pop on tomorrow's docket, so I'll reach out to you tomorrow regardless.
Yes, Your Honor. Thank you.
Okay.
Hi, good morning.
Good morning, Ms. Dixon. Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one.
Yes, Your Honor. On February 24th, 2024, at approximately 11:27 a.m., the officer did a license plate check on a vehicle that was shown to be registered to have active Class B warrants out of Montgomery County for driving while license invalid, and 6 Class C warrants from Humboldt Police Department. The registered owner was shown to be a Black female, and that female was seen driving the vehicle through the lower driver's side window, giving the officer reason to believe that the registered.
Let's break this down. Driving with a suspended license isn't just a traffic issue, it's a fast track to jail. And this judge isn't having excuses. Period. If she drives again, she's risking everything.
Owner was currently driving that vehicle at the time. A traffic stop was initiated. The officer made contact with the defendant, who was identified by her Texas driver's license. The officer ran the defendant's information and showed that her license was ineligible and that she did not have any confirmed insurance. The Montgomery County Sheriff's Office and Humble PD confirmed the warrants.
Hey, can you run her license down?
Yes, Your Honor. It is not eligible right
And
now.
Ms. Dixon, I'm
Yes,
going to
sir.
find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive. I do not care what's going on in your life. If you do not have a Texas driver license and liability insurance in your name, you are not allowed to drive. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
I have one question.
Stop. This is not the time for that. If you need, I can provide you a lawyer today, but this isn't where you just get to start asking questions. It's number one. Number two, this is a court. When you come to court, please dress appropriately, okay? So I'll have you go fill out an application with Miranda. I'm gonna have you sign a receipt with Victoria. I'll have you take a seat in the jury box while we get your bond conditions, and then we'll have you speak to a lawyer in the material. Please. How's Jen? Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always be 6 feet under, right?
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old, and you've been out literally. She's been on the land for 10 years, Dave?
Well, the warrant was on November 9, 2015 for this one, Judge. But the surrender for the judgment roll was on, well, actually, the enrollment date was February 16th, but the surrender notice to file was April 2020. So I don't know what kind of efforts they went, but the actual forfeiture date was in 2015.
Do we know, do they really want, are they going to
I
come?
mean, that's, like with the other ones, I can only confirm the initial teletype confirming that the warrant is valid and they do still want her.
We've tried to reach out to, I'm sorry, Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of a case is it? Are they really going to come back? But he's been unable to reach anyone. And I mean, it's only been, 30, 45 minutes. So, your lawyer's asking me to set you a bond. Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for.
Your Honor, the state's asking for $10,000 because it is a possession of controlled substance with intent for oxycodone and the fact that it's been in forfeiture status since 2015. This isn't one where it's a to-be warrant. It's one where she appeared in front of a judge, stated she would return, and then she didn't do that.
You want?
$1,500, Judge. My client has expressed to me that she is a college student. She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she doesn't want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connection or contacts with police that were dismissed or otherwise, except for this one case from 2015.
The thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, it's only going to be one time. I won't do it again. You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at $5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
It's in Mississippi, Harrison County, Judge.
Go.
So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, I mean, you can't run forever, right? We're going to get you again. And this time I will physically hold you until Louisiana comes and gets you. Do you understand?
I do, Your Honor.
Okay.
So just knowing that he has made the bond for $5,000, is that something that you can are you or your family is able to post, because if not,
5,000 cash?
it's 5,000.
Oh no, I have a deaf baby. I'm a single parent. My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side, just to help,
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time and see which one happens first. So if
Wow.
you're not going to be able to pay the money, then you can, the option is to leave the waiver that you have in place that you signed on, I think 2/27, and then let them see if they're going to come get you or not. But your time, you don't lose the time that you've already been in custody.
So when you buy, I'm confused, when you behind,
What did she waive?
Right off the bat, 227?
February 27th.
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active. And that warrant will always remain active until you physically go back or somehow go back to Louisiana and take care of it. That said, if you want to make this bond, you have to withdraw that waiver that you have, and then you lose those 6 days. So if you withdraw it and you don't make the bond, you lose all that time, and you basically it's told until you re-waive or you make that bond.
I only say this because of the age of the case and the fact that I didn't know she had counsel in Mississippi. It's very, very rare, but I have been seeing it happen here and there, is if local counsel there can get a new setting date. Like I said, it's incredibly rare. I can count on one hand.
This is the turning point. A 10-year-old case, a $5,000 bond, and a court that's run out of patience. Should the system be this harsh for a decade-old mistake? Drop your thoughts in the comments. Has justice gone too far, or is the judge just doing her job?
The amount of times it's happened.
What do you mean, get a new setting date?
So even if they don't appear with sufficient evidence from our sheriff's office that she's in our custody and her persons is here, and for a variety of factors, I can't speak to Mississippi because I'm not licensed there and I don't work there, is whatever sufficient factors they have to set a new date for her to self-surrender versus outside of the fugitive, they will recall the warrant. So like I said, it's incredibly, incredibly rare, but only because of the age of the warrant and the fact that she has counsel there.
But we don't know that.
Well, but I'm saying if the information for that counsel can be sent to.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You've been I need you to understand that we mean business. I'm not here to play games. And so that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, but
I'll stand down. Thank you, Judge.
sure. So,
Yeah.
so
Yes, sir.
I'll let you guys go talk.
Okay, sir.
I want you to say something here that you might invariably regret because it's in front of everyone, Okay, please.
Thank you, Judge.
Thank you,
I'll
Judge.
go down some, but a reasonable amount. All right. Mr. Lumumba, you are charged with 2 counts of driving while intoxicated. You've worked out an agreement. They're going to dismiss one in exchange for your plea on the other one. Pleading on 089. This one is, they're all both 08. The agreement that you have is 180 days in jail, to be probated for 15 months. As part of the agreement, you will do a DWI education class. You will do 3 victim impact panels: substance abuse treatment. You will also do what's called a TRAS. The TRAS is an evaluation to see what other conditions you may need. They will probably, because the fact that you have 2 open DWIs, they will probably add other conditions. It may be supportive outpatient treatment. It may be intensive outpatient treatment. I don't know. It may be inpatient. I have no idea. You must fulfill whatever other conditions they assess on you. No drugs, no alcohol,